Hi everybody, Keith here. Hey, wanted to go over another word with you here real quick, and basically we're looking at right now it's Black's Law Dictionary, 4th edition, page 140, and the word is arrest, as in cardiac arrest. It's a medical term used to describe the stoppage of the heart, cardiac arrest, stoppage. And here in Black's Law Dictionary it says arrest, to deprive a person of his liberty by legal authority, taking under real or assumed authority custody of another for the purpose of holding or detaining him to answer a criminal charge or civil demand. Physical seizure of person by arresting officer or submission to officer's authority and control is necessary to constitute an arrest. In other words, again, the stoppage. So when they turn on the lights and you stop, that is the arrest. You are arrested. It is a restraint, however slight, on another's liberty to come and go. It is a restraint, however slight, on another's liberty to come and go. It is the taking, seizing, or detaining the person of another, touching or putting hands upon him in the execution of process, or any act indicating an intention to arrest. One of the means which the law gives the creditor to secure the person of his debtor while the suit is pending, or to compel him to give security for his appearance after judgment. As ordinarily used, the terms arrest and attachment coincide in meaning to some extent, though in strictness, as a distinction, an arrest may be said to be the act resulting from the service of an attachment, and in the more extended sense which is sometimes given to attachment, including the act of taking, it would seem to differ from arrest in that it is more peculiarly applicable to a taking of property, while arrest is more commonly used in speaking of persons. I want to go back to this real quick here. Though, let's see, as ordinarily used, the terms arrest and attachment coincide in meaning to some extent. And what they're talking about there, attachment, they're talking about, say, a warrant. It's a document. It's the attachment to the arrest. It's the cause or the reason behind the arrest. Arrest is also applied in some instances to a seizure and detention of personal chattels, especially of ships and vessels. Thus, in admiralty actions, a ship or cargo is arrested when the marshal has served the writ in action in rem. Civil practice, the apprehension of a person by virtue of a lawful authority to answer the demand against him in a civil action. And if you remember earlier, we talked about civil and citizen in previous video I did. Civil is your civil rights because you're a citizen, a 14th Amendment citizen. The apprehension of a person by virtue of lawful authority in that case is a officer of the law. You're claiming to be a 14th Amendment citizen of the corporation, an employee, a member of that corporation, then that corporation has authority over you. If you are not a citizen, then they don't. Walmart can't call you up and tell you need to attend an employee meeting because you're not an employee. Criminal cases, the apprehending or detaining of the person in order to be forthcoming to answer an alleged or suspected crime. The arrest is said to be more properly used in civil cases and apprehension in criminal. Thus, a man is arrested under capias ad respondendum and apprehended under a warrant, charging him with larceny. In other words, that's those documents I was telling you about. If you're being arrested, it's because they have a what they're calling a capias ad respondendum. In other words, they've got a corporate order to have you appear. When you are apprehended under a warrant charging you with a larceny, which is such thing as a crime, where you harmed or injured another person or caused them to suffer loss or damage to their property, that is an apprehension. When you're being arrested, that is a corporate action. Now it says malicious arrest, an arrest made willfully and without probable cause, but in the course of a regular proceeding. Regular proceeding. That's again another corporate term, proceeding, because you don't proceed in life, you live life. And if you're living a life in the private side of things, then they have no right to proceed against you in any manner unless it's a apprehension. Parole arrest, one ordered by a judge or magistrate from the bench, without written complaint or other proceedings, of a person who is present before him, and which is executed on the spot, as in case of breach of the peace in open court. Rearrest, right of an officer to take without warrant one forcibly freeing himself after arrest. Escaping in any manner, or violating parole, to respond to bond for appearance. Second arrest, different from rearrest, is the second arrest forbidden after discharge on a habeas corpus, means an imprisonment based on the same information and not under a new information followed by a lawful warrant. Warrant of arrest, a written order issued and signed by a magistrate directed to a peace officer or some other person specially named and commanding him to arrest the body of a person named in it who is accused of an offense. And then it says, this is somewhere else, an arrest may be said to be the act of resulting from the service of an attachment. Yeah, that's what I was talking about earlier here. In other words, that's that warrant or that capia ad respondendum, depending on what court is doing it. If it's a lawful court being presented as a claim by another man, then it would be a apprehension. If it's made through the corporate United States district courts, it would be then a arrest. Or through a corporate organization such as your local municipal police, county sheriff's department, things like that, state patrol. They're all corporations, and they're all part of that corporation arresting people. And the only time they apprehend anybody is if you've actually committed a crime. Otherwise, if you're not a citizen and they're arresting you, they're the ones committing the crime. The apprehension of a person by virtue of a lawful authority to answer the demand against him in a civil action. And then we have, if we look up that part earlier, the capias ad respondendum, just so we can get that cleared up. It says, in the common law legal systems, capias ad respondendum, and it says it's the Latin that you may capture him in order for him to reply. Capias ad respondendum is or was a writ issued by a court to the sheriff of a particular county to bring the defendant, having failed to appear, to answer a civil action against him. In other words, if they give you a ticket and you don't appear in court, what they would then issue would be a capias ad respondendum if you actually committed a crime. In Black's Law Dictionary on page 261, again, that's 4th edition, it says capias ad respondendum, and it says a judicial writ, usually simply termed a capias and commonly abbreviated to CARESP, by which actions at law were frequently commenced. In other words, today you have more of officers arresting you simply because they think they have that lawful authority without any kind of paperwork. such as the capias ad respondendum or a warrant or anything. Then it says, and which commands the sheriff to take the defendant and him safely keep, so that he may have his body before the court on a certain day to answer the plaintiff in the action. It notifies defendant to defend suit and procures his arrest until security for plaintiff's claim is furnished. Okay, again, I think they used that in the wrong sense there. If they're saying it's an arrest on a claim, it should be an apprehension on a claim. So again, they're either misconveying words or something there. But either way, just so you know, an arrest is simply like a cardiac arrest. Stoppage. Once they stop you, you are under arrest. You do not have to be placed in cuffs to be under arrest. They stop you. You are already under arrest. Anyway, just so you know, God bless. Love y'all. Have a good day.